Thompson?
You're now the attorney in fact for the state name.
No, sir, Mr. Thompson. You know I don't put up with any of that. You understand?
Right.
Listen to me.
Yes, sir. Go ahead.
You understand I'm not going to put up with that.
Yes, sir.
Not anything like that. You understand? Do you understand me?
Yes.
There's not going to be any private citizen, sovereign citizen.
Welcome back to the courtroom, folks, and buckle up, because today's session is a full-on roller coaster of sovereign citizen logic, legal smackdowns, and a judge who has absolutely zero time for nonsense. Judge Bradley Clark runs his courtroom like a finely tuned machine, firm, fast, and fearless. And the moment the defendant tries to go down the sovereign citizen route, Judge Clark shuts it down before the words private citizen even fully leave his mouth. Now, sovereign citizen ideology has popped up all over the country, people insisting they're not bound by laws, that their cars are traveling vessels, or that their license plates are private property rather than a vehicle registration. But Judge Clark has seen it all. He's not impressed. And in today's lineup, you're going to see him handle every twist, every delay tactic, and every made-up legal term with one consistent response. Today's episode spans 4 different hearings, each with its own flavor of chaos. One defendant claims a treaty from 1819 protects his right to drive high. Another tries to rewrite legal terminology on the spot. At one point, the judge nearly asks a legally dangerous question, catches himself, and course corrects instantly. That moment alone shows why courtroom awareness matters, and just wait, later, we're going to see a defendant try to cross-examine a police officer into admitting absolutely nothing he wants. It's like watching a ping-pong match where only one player knows the rules. By the end, you'll see how Judge Clark manages to steer every hearing back on track, no matter how sideways things get, and trust me, they get sideways.
It doesn't make any sense. I've denied most of it. I'm going to probably deny the rest of it.
Really?
Yes, sir.
All right.
Absolutely.
I got some education to go, huh?
Sir?
So I've got some education to go.
Yes, sir. You're here today by, you got a new law violation of driving my license suspended or revoked. You don't want to have an attorney appointed to represent you?
No, sir.
Are you sure?
But that's the thing is, I've never even been pulled over. I don't know how I got a license or a warrant or anything. I haven't been pulled over in more than a year. Any emergency contact. I went to go pick up a records request and they gave me a warrant instead of the records.
Do y'all know anything about this?
As to the new law.
Do you have a driver's license?
No, sir.
Don't answer that. I shouldn't ask that question.
Fair enough. Fair enough.
Strike that from the record.
This moment right here is a perfect example of judicial precision in real time. When the judge says, "Don't answer that, strike it from the record," he's catching himself before accidentally letting the defendant incriminate himself. Now, for anyone unfamiliar with courtroom dynamics, a defendant admitting to something like driving without a license can be used against them down the line. If the judge had allowed that answer on the record, the defendant could later challenge the decision by claiming improper questioning or arguing he was led into self-incrimination. This is exactly why judges must maintain strict boundaries, especially when defendants choose to represent themselves. Without an attorney present, the judge has to walk a tight line, firm enough to maintain order, but careful enough to avoid unintentionally violating rights. It also highlights the problem with defendants who insist on handling cases alone. They don't always understand the stakes of what they're admitting. One slip-up, one mistaken yes, and they could sink their entire
Court file.
I tried to and they wouldn't accept it.
All right. Was he arrested? Is there a new arrest for driving license suspended or revoked? State?
Yes, there was a bench warrant issued on 1/23/24 that's executed 1/29/24.
Said I was just doing a records request and had an agreed upon date to pick it up. Went up there to pick it up and gave me a warrant. So the records are requested.
I tell you what, I'm gonna let y'all
Return
do that. Listen, I'm gonna leave him on probation. I'm gonna set this for preliminary on April. What's that April date?
April 17th.
April 17th. I'm gonna let him take care of that in county court and see what happens. Okay.
Thank you.
And I think that's the only violation he had.
Yes, sir.
Keep doing what you're doing.
The moderator is absolutely right. This could have become a huge issue if Judge Clark hadn't corrected himself in time. When dealing with self-represented defendants, especially sovereign citizens, there's always a risk that a judge's questions could be misinterpreted or used as ammunition on appeal. Sovereign citizens love to claim their rights were violated, often by misquoting legal statutes they found in a Facebook group or half remembered from a YouTube video. In this case, the defendant's whole argument seems built around the idea that he never should have been charged because he wasn't pulled over, as if physical traffic stop conditions somehow wipe away legal responsibility. It's like arguing a parking ticket doesn't count because you were only temporarily stationed in the spot. Judge Clark's awareness is key. He knows defendants may twist anything said in court. So he protects the record, protects the process, and ultimately prevents unnecessary appeals. It's a subtle moment, but incredibly important.
Mr. Alexander, I don't accept any of that. If you want to state your name, state your name. If you don't, that's fine.
I'm Cedric Alexander, the beneficiary, sir.
No, sir, I don't, the beneficiary doesn't mean anything to me, says, are you Cedric Alexander?
I'm a human being, Cedric Alexander, not the corporation.
Why don't we hell with that?
I'm a human being, not a fictitious entity.
On your first appearance, I'm going to appoint the Office of Public Defender. You've got a failure to appear on a, misdemeanors. I have ordered to be held without bond on that. I'm going to leave that as it is. You got a possession of methamphetamine and see, that might be all the same thing. Yeah. You just got a failure to appear.
The officer didn't even come and do depositions because there's a lot.
You've got to drive my license, suspended or vote. I'm gonna find there's probable cause. I'm gonna set. That's a third degree felony, punished for 5 years. Florida Department of Corrections.
$5,000.
I am going to set a $5,000 bond. I'll see you March 11th at 9 o'clock. Good luck.
Judge Clark brings the first hearing to a close, neatly balancing firmness and fairness. Notice how he doesn't jump straight to jail time or punishment. He gives the defendant a pathway to resolve the issue in county court first. Judges aren't out to get anyone. Their goal is order, legal compliance, and due process. But here's the twist: even with the judge offering leniency, the defendant's earlier insistence on confusing pseudo-legal jargon could have made this much harder. Sovereign citizen arguments never help. They don't shorten hearings. They don't impress judges. And they definitely don't make charges disappear. Yet Judge Clark remains calm. He sets a date. He gives clear instructions. He keeps the door open for accountability rather than escalation. This is judicial professionalism at work. Even when the courtroom energy is chaotic, the judge keeps everything on track.
All right. Mr. You can call your first witness.
All right, state calls officer Zip. Richard Zip.
All right. Just swear the witness in.
I do.
Can you state your name for the record, please?
Richard Ziff,
Where are you employed?
Panel City Police Department.
Were you working in November of 2023?
I was.
On November 11th, 2023, did you have occasion to come in contact with defendant Josiah Beecham?
I was.
How did you come in contact with him?
It was an investigated stop. Mr. Beecham's vehicle was having a hard time maintaining its lane. I conducted a traffic stop on the vehicle. Vehicle drove over the curb. Immediately when I stopped the vehicle, I can smell marijuana coming from within the vehicle while still sitting inside my own vehicle. As I got closer to the vehicle, I can smell the marijuana getting stronger. When I made contact with Mr. Beecham in the driver's seat, I informed him the nature of the stop, also told him I smelled marijuana in the vehicle. At that point, Mr. Beecham was saying I was violating the Treaty of Florida, making other statements that...
Here's where the courtroom energy shifts. We move from procedural cleanup into full-blown cross-examination mode, and the defendant steps into a role he's clearly not prepared for, acting as his own attorney. Now, good cross-examination asks precise questions, exposes weaknesses, and builds a narrative. This cross-examination does none of that right away. You can tell the defendant is trying to poke holes in the officer's credibility, but he's missing the fundamentals. Instead of focusing on contradictions, he keeps circling back to irrelevant details like whether there was traffic on the road or whether the officer had to catch up to him. Meanwhile, the officer stays calm, consistent, and straightforward. He describes lane drifting, curb contact, marijuana odor, controlled substances, and a firearm under the seat. This is where self-representation becomes risky. The defendant is trying to create doubt, but every answer from the officer only reinforces the strength of the state's case. Even worse, his questions often open the door for the officer to repeat damaging facts. Instead of disproving anything, he's helping the prosecution.
Person.
I did.
During that search, did you locate anything of note, of significance?
We found trafficking amounts of controlled substances. I believe we were, one of them tested positive for cocaine. There was marijuana, and we believe fentanyl.
Did you find any firearms during the search?
There was a firearm located underneath the driver's seat that Mr. Beecham.
Is a turning point in the hearing because the officer's testimony confirms multiple layers of evidence: the smell, the drifting, the attitude on the scene, the controlled substances, and the firearm. When these elements stack together, it becomes harder and harder for the defendant to argue that the stop wasn't justified. Now, sovereign citizens often latch onto one specific procedural element, in this case, the lack of a dashcam or a traffic ticket, as if removing that single piece invalidates everything else. But probable cause doesn't need video. It doesn't need a printed citation. It needs observable, articulable facts, and the officer provides them clearly. The defendant keeps asking whether the drugs could have belonged to the passenger, but that's not the standard. Legally, what matters is control and proximity. Drugs in your pocket? Drugs behind your seat? That's what courts call constructive and actual.
Any felonies?
He was on inmate release status for a felony. I believe the same charges.
No, that's all my questions at this time.
Mr. Beecham, any questions?
Yes. So did I have a passenger in the car with me at the time?
You did?
Upon you saying you smelled the smell of marijuana, did I say that I smoked hemp?
You did admit to it.
I said I smoked hemp, right?
You said you smoked marijuana.
Sir, did you have on a body cam?
I did.
And okay, thank you, Your Honor. So I said, so your body cam was on at the time, and did you get any competent basis on the traffic stop as far as like a recording of that video?
I don't have a dash cam.
You don't have a dash cam in your car?
We don't have dash cams in Panama State Police
Okay.
cars.
It's cool. And that was failing to maintain the lane. Okay, was it any other traffic on the road?
You were the only vehicle.
Okay, and how long were you behind me before you actually pulled me over?
I was behind you about 2 blocks, watched you drift over the center line several times.
Several times, drift off the line. Did you have to catch up to me? Your Honor, I have a dash cam and rear view cam. I'm probably gonna introduce the, what you call it. Did you actually have to catch up to my vehicle, or?
I did not have to catch up that much. I was right behind you.
I'm saying that the stretch of the road was, we was traveling on Beach Drive, that's right?
Yes.
And you were behind me the entire stretch of Beach Drive?
No, I was behind you by Balboa.
By Balboa is when you got behind me. Okay, and so when did you notify me or the passenger about any of the drugs or gun?
Immediately.
Immediately? And what was said about the drugs or gun? What did the passenger say?
The gun was found after you were already detained. We searched the vehicle and it was underneath your seat.
Okay, and was the vehicle registered to me?
Vehicle was registered to your girlfriend.
Okay. And so where were the drugs or anything found in the vehicle?
You had drugs in your pocket. And there was also drugs in the back seat behind your seat.
And you found the drugs?
I found a bag of white substance in your right front pocket.
What about any vehicles in the car?
There was a bag in behind the driver's seat that had several other bags that were wrapped in a clear plastic baggies that was behind your seat.
Okay, and so what did you question the passenger on?
That would be my partners who questioned the passenger. I questioned you.
Yes, and what did I admit to any of the drugs?
You refused to talk to me other than saying I was violating the Treaty of Florida.
Exactly. And so you notified me on drugs being found in the car on the scene, you're saying?
Everything was notified to you. I tried reading you implied consent. You refused to actually listen to me. You kept on saying I was violating the Treaty of Florida and you.
Yeah, I was saying.
Defendant seems to be hoping that if he keeps circling the same questions, he'll uncover some kind of procedural slip-up. But what we're actually seeing is a well-trained officer maintaining consistency under pressure. Drifting, marijuana odor, multiple bags of drugs, and a firearm under the seat, the cause for the stop, the actions after the stop, and the evidence found all line up cleanly. Meanwhile, the defendant continues trying to introduce doubt where none exists. He asks whether the officer had eyes on the passenger, as if shifting attention for a few seconds somehow nullifies the drugs found in his pocket. Then he points to the lack of a lane drift ticket, as though the absence of that citation erases the marijuana odor or the controlled substances. It doesn't, and the officer's responses are consistent every time. The affidavit outlines the arrest, not the reason for the stop. The full details are in the lengthy report, which is standard. Nothing unusual. Nothing improper. This is the danger of self-representation. The defendant is trying to build his defense on misunderstandings of legal procedure rather than actual weaknesses in the evidence. And the judge? He's letting the defendant talk, but he's not
or not, because the second thing I would address is the state's filed a motion in limine that we object to. Depending on the ruling there, I'm not sure if that will affect Mr. Baker's decision.
All right, well, let's take it the motion in limine right now. It's the motion in limine. Mr. Ferrer, you filed it?
Yes, Your Honor. The state is moving, Your Honor, to exclude testimony of two things. First is testimony for the legality of his license plate, or any sort. My understanding is that Mr. Meredith intended to elicit testimony about the origin of the license plate. We feel that the probable cause is enough already with the rolling stop. That it would be irrelevant. The defendant is no longer in charge of any type of traffic offense. They're not legal defenses to the charge that he's brought with fleeing to eluding in the possession of drugs.
Your Honor, the state intends to introduce some body cam from Officer Elkins as in relation to the original stop, and Mr. Baker has his hands out of the window and is talking to the officer about what the reason for the stop is. There is a tag that's on there. In the edited version of the body cam, it is mentioned that the two reasons for the stop were rolling through a stop sign and either, I can't remember if it was bad tag or no tag or whatever. But I think that it's important for the jury to understand that the origin of this tag and what it represented. I, as an officer of the court and under the rules of the bar, I don't believe I could argue that it is a valid tag, but I think the origin of it is important for the.
It's not a valid tag. What does it matter what origin or the origin of this?
Well,
I'm not going down that road,
Mr. Baker felt that it was a legal tag.
Was it issued from the Department of Motor Vehicles from the state of Florida?
It was not.
Or the tax collector's office? It's not a legal tag.
If you'd like to see a photocopy of what it is.
It's a tag, yeah.
My tag is from the DOT. It's a DOT number because my tag belongs to my trust. My DOT number is valid. So why wouldn't the tag be?
Nope, not going in. We're not going to talk about it.
Can I put anything on the record?
You can put it on the record, but I'm telling you, I'm not anything that's not a legal tag from the state of from one of the states of the United States, or I guess
it is. You got the information yesterday. He emailed you the information where the tag came from and what was going on with the tag.
Your Honor,
I can't have a custom tag.
Let Mr. Meredith make your argument, sir, please.
Your Honor, the number that's contained on the tag, the 412-5492, is a Department of Transportation number that is assigned to Mr. Baker. I have gone on their website. You can search that number, and when you do, it comes up with Mr. Baker's name, his address, and all his information. Now, depending on what we're allowed to do, his testimony would be as how he had obtained this and had gone through and got it from a third party in New Jersey. And because it had the Department of Transportation logo, which is the actual logo from the Department of Transportation, and it had his actual identifying number from the United States Department of Transportation, that he could display it.
Is it a legal valid tag? Can you make that argument?
Yes. I cannot.
Okay, it's not coming in.
When you run the tag number,
It is Judge Clark's patience meets its limit as he delivers the critical legal reality. Whether the officer wrote a traffic ticket or not is irrelevant. The probable cause for the stop, the officer's observations, and the evidence found during the search carry far more weight than a missing citation. The law doesn't hinge on paperwork technicalities, it hinges on facts, and in this case, the facts overwhelmingly support the stop, the arrest, and the charges. Throughout all 4 hearings, Judge Clark maintains control, clarity, and composure. He deals with sovereign citizen terminology, self-represented defendants, historical treaties, and courtroom theatrics, all while ensuring due process is followed. Even when defendants wander into fantasy arguments or try to outlegal the legal system, Judge Clark stays steady, grounded, and unbothered. If you found this case as shocking, chaotic, and wildly entertaining as we did, hit that like button, share your thoughts in the comments below, and don't forget to subscribe for more jaw-dropping courtroom moments and expert breakdowns. Trust me, you won't want to miss what's coming next.
In terms of defenses related to the defendant's status as a sovereign and/or a private citizen, I like to point the court to controlling authority in Barber versus Bay County Sheriff's Office Jail Facility. For the record, the site of that is 308 3rd Southern. It starts on page 254. I like to quote from this case, Your Honor, that says the sovereign citizen theory has no basis in the law, and parties that make it are in danger of court sanctions. And to our knowledge, no court in this country has ever found sovereign citizens to have any merit. They're relying on the 7th Circuit Court of Appeals decision in the United States versus Beneby. For the record, that's 654, 3rd Federal 753, where it talks about where it's just not specifically about sovereign citizens, but encapsulates all of the arguments there. So regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction, and the court is correct in rejecting all of those claims. However, they are presented and they should be rejected summarily.
We're not raising it as a defense, but I believe that Mr. Baker testifies for the jury to understand what was in his mind on October 7th of this past year. They need to understand his ideology, his understanding of